Trusts 101, the basics of trusts. Many Americans will lose tens of thousands of dollars because they have been misinformed on the basics of trusts. This is attorney Jim Daloisio. I am the Director of Legal Services at Torchlight Tax and have been working with its CEO, Dave Horwedel, since 2017. Today I am going over trusts basics. I call this Trusts 101. We are going to define the basic types of trusts and the potential benefits. You are also welcome to contact us at Torchlight Tax if you have questions about trusts, asset protection, or taxes. We will be glad to give you a free consultation even if you do not watch the entire video. For a free consultation, you can call us at 1-877-758-7797 or email us at info@torchlighttax.com. The first question really is, what is a trust? A trust is a contract between the grantor, which is the person that creates the trust, the trustee, who is the person that manages the trust, and the beneficiaries, who are the people that are going to benefit from the trust. The trust gives the rules about what happens with assets and how the grantor, trustee, and beneficiaries interact. If you create the trust, you set the rules. The grantor sets the rules. Now, you want to make sure that your rules do not violate the law and they achieve your purposes in setting up the trust. This is important because if you don't make your rule book, you're going to get the rule book that the state gives you. You're going to follow the state's rules. And if your trust document has provisions in it that violate the law, that can ruin everything. Also, you can accidentally put provisions in the trust document that hurt your own interests. This is why it is important that you have someone who knows what they are doing put together your trust documents. So you make the rule book, but you need to do it with competent legal support or otherwise you may shoot yourself in the foot. There are two main types of trust. The first is testamentary trust. Testamentary means relating to or bequeathed or appointed through a will. Thus, a testamentary trust is one that is created in a will. The trust does not exist during your lifetime because it is in a will and does not come into action until your death. So, a testamentary trust does not do anything for you or your beneficiaries while you are alive. Okay, so you write out your will. Per your will, your 30-year-old son Bob is going to inherit your home, your business, and your rental properties. Great. Suppose you get into an accident and are alive, but in a coma. You cannot run the business, collect rent, maintain your home, or pay the bills. Bob has no access to your bank accounts. Bob cannot collect the rent. Bob cannot run the business. A testamentary trust doesn't transition control of assets in the event of a disability. So if you're alive and you get sick or disabled, a testamentary trust does not enable somebody to take control of your assets in the event of disability. Now, if you and your wife are simply working W-2 jobs and there is no business involved and no major assets, this may not be necessary. One key benefit of a living trust is that it allows the trustee, who you pick and trust, to take over in an emergency. What does the will do? The will makes your wishes known to the court and sets up a testamentary trust at your death. It is going to direct instructions to the probate court, and your beneficiaries should inherit the properties you bequeath to them via a court, called the probate court. A will is inherently a document intended for probate. It's going to require a probate proceeding to create this testamentary or death trust. The problem with living wills and their resulting testamentary trusts is that you have involved the court system in your personal affairs. Who pays the legal fees for probate? Your estate. This does not sound very good, does it? The main person who benefits is the attorney who is hired by the court to make sure the will is faithfully executed. The attorney gets paid when your will goes into probate. It can be a bit misleading. You want to make sure your wife and kids inherit if something happens to you. You call up an attorney and he quotes you a low price for the will. You pay for it, go down to his office and write up your will. You ask him, "Should I get a trust?" "No need," he says. "A will handle it just fine." 2 years later, you get run over by a speeding limousine. Your spouse goes to court, and your attorney may be paid thousands and thousands of dollars out of your estate to execute the will. I would recommend you take the instructions of any attorney who tells you no trust is necessary with a grain of salt, especially if there is real estate, companies, or other substantial assets involved. Okay? So, a will sets up a testamentary or death trust upon your death. There is a different kind of trust called the living trust. It is called a living trust as it exists while you are living, unlike a testamentary trust that doesn't exist until after you're dead. A living trust can shift control of assets in the simplest way possible in the event of disability or death, if that is the way you set it up. So, your son Bob could take control of the trust as trustee in the event of your disability. What assets does the trust control? The assets you have put into the trust. This is called funding the trust. If you properly fund it, a living trust avoids probate, which is the biggest reason why people like trusts. Living trusts come in two categories: revocable and irrevocable. Revocable and irrevocable living trusts are definitely two totally different legal strategies. They accomplish different goals. Revocable living trusts are the most common. When people say, "I already have a trust," 99% of the time they are talking about a revocable living trust. The main reason people put together a revocable living trust is to avoid probate. They also can shift control of your assets in the easiest way possible, both if you are sick or upon your death. They are also private if you keep it that way. This is a big advantage over probate, where there is a court proceeding and everything goes into the public record, where it can open a can of worms. Also, a properly structured revocable living trust can provide asset protection to your loved ones after your death. It's important to understand, revocable living trusts do not provide asset protection to you during your lifetime. If it's your trust, a revocable living trust is not intended to provide asset protection to you. This is one of the biggest misconceptions about revocable living trusts out there. People get upset because they believe that their revocable living trust provides them asset protection during their lifetime. This is almost entirely not true. This is not the purpose of a revocable living trust. It is not what it is meant to do. That's why there are irrevocable living trusts. Once again, we create them while we're alive. These are mostly used for tax planning and asset protection. Most people consider that irrevocable trusts are for very wealthy people. This is changing. One of the reasons for this is what is considered very wealthy is changing. Millionaires used to be very wealthy. Not anymore. There are millionaires living paycheck to paycheck and struggling to pay their bills and mortgages. Suppose you have 4 kids and live in a home you own in a decent area of Los Angeles. Maybe your mother-in-law stays in your home. Your 4 children probably each have their own room in your home. That's 6 bedrooms. This is probably a $2 to $6 million home, maybe more. 15 years ago, maybe it was a $1 million house. If you have lived in it for 15 years, you probably have $1 million or millions of dollars in equity. But with 4 kids, a wife, and a mother-in-law, you can still be living paycheck to paycheck. You don't feel wealthy. You just have a house your family can live in and may live in terror about losing your job. Irrevocable trusts can be drafted to give you asset protection during your life and for your loved ones after death. We can protect assets from the nursing home, from predators, lawsuits, and so on, using irrevocable trusts. The idea that only the wealthy use irrevocable trusts can be dangerous. You are not wealthy. Say you have $2 million equity in your 6-bedroom home, are struggling to make your payments and have your 4 children and mother-in-law living with you. You get sued and lose. There goes that $2 million in equity along with the house. An irrevocable trust could have prevented this. You may not have felt wealthy, but after the $2 million is gone, you sure feel a lot poorer. Now, when we're talking about trusts, it's important to understand that if you have a trust, you want to use the trust. Suppose you have 401ks, IRAs, or insurance that you have named a beneficiary for. If you want the trust to oversee how this money is handled, make the beneficiary the trust. Now, if the beneficiary is someone that needs no trust supervision, you can leave it out of the trust. Maybe you are fine with your brother, who is a successful realtor and real estate investor, getting $50,000 in an IRA, and do not care if it goes through your trust. He knows what to do with it. But what about your 18-year-old grandson? If you want the trust to ensure he spends his inheritance on education or some such, then make sure that it does not go to him direct by a beneficiary designation. Sometimes people will go to their bank or they'll go to their financial planner and they'll say, well, you're all set. I did your beneficiary designations for you. You're not necessarily all set because your beneficiary designations are not going to create the same type of plan that your estate plan, whether it's a will or a trust, would do. When you're talking to people at your bank or you're talking to your financial planner, you must understand they're probably well-meaning, but they're not lawyers, and they're telling you only a very small piece of the story. The piece of the story they're not telling you, because they're not lawyers and they don't deal with this stuff all the time, is your beneficiary designations are not going to protect your assets if your children or other beneficiary gets divorced, sued, or if they are bad with money. Now, if you are fine with your son blowing his inheritance gambling in Las Vegas, then maybe you do not need a trust to protect him. If your son's wife divorces him and takes half the money he inherited, that may be okay with you. No will is going to protect the money they inherited from you from these things, but a trust could. If your heirs are having issues with addiction or they're not able to manage their own affairs because they're sick, then a trust might help them out. Maybe a relative you trust could be the trustee and oversee the trust for the benefit of your children. Now, if the kids are strung out on drugs, this trusted relative is not going to give them money for more drugs. But maybe he would pay for a treatment center. Maybe they need nursing home care, or they're sick, or they have a disability, or they have creditors, or they are going through bankruptcy. Beneficiary designations do not protect from any of these things, but a trust could. That's why I'm saying, if somebody tells you that you're all set with your beneficiary designation, well, you're not all set with all these things. A lot of times, at least with my clients, they want to be all set with these things. So that's why you want to have both a properly written and funded trust, because it can protect your money. But you must have the right kind of trust. That's also why funding your trust is critically important. So, what is funding the trust? Well, funding the trust is the process of moving your assets into your trust. This gets a little confusing for people sometimes. Imagine that you have a bowl, and you've got fruit in your bowl, right? If you take an apple, and it's outside of the bowl, and you put it inside the bowl, is it still an apple? This is the way that the trust works. A trust is like the bowl. The apple is your bank account. You put the bank account inside the bowl or inside your trust, it's still your bank account. Just like an apple is still an apple. But you need to get it in there. And that's the thing that most people are not doing. Even people that have trusts, they're not funding their trusts. So it's really important to understand that if your assets are not held by your trust, the trust isn't worth the paper it's written on. You have an expensive legal document that is not actually doing anything for you. So it's critical to fund your trust. Also, understand that when your trust is unfunded, this means you are probably going to wind up in probate anyway. So the reason that you set up the trust is not even going to happen. Your trust is going to be empty, and it's not going to protect your assets from probate. So, an unfunded trust equals probate. That's a big fail. We don't want that. This is just a quick Trusts 101. I know I just threw a lot of information at you. There is a lot to this topic of trusts. They are a major tool to protect your assets. There are other major tools to protect your assets. The LLC, Limited Liability Company, is another one. I suggest you watch our videos on Asset Protection 2024 and using living trusts to avoid probate. They are different asset protection strategies. Using anonymous LLCs to hold your assets can create a situation where would-be suing lawyers cannot see your assets, and so they do not sue. Irrevocable domestic asset protection trusts can also be a formidable barrier. Foreign asset protection trusts can be practically unbreakable. Torchlight Tax and Financial Solutions has a number of fully legal strategies to protect you from overtaxation and also has strategies to protect your assets. These are not one-size-fits-all. A young single mechanic working in an auto shop has minimal needs. If he becomes a shop owner, gets married, or buys his own home, his needs change. As assets and responsibilities increase, asset protection strategies become more sophisticated. You are welcome to contact Torchlight Tax for a free consultation. You can call us at 1-877-758-7797 or email us at freeconsultation@torchlighttax.com. You are also invited to like this video, subscribe to our YouTube channel, share the video, or visit our websites at torchlighttax.com or guarddogtax.com. Once again, this is attorney Jim Daloisio. I hope you found this video helpful. Due to the overly litigious nature of our current society, it is important you get educated on some of these topics. Good luck. Give us a call if you need any help.